Are you hearing me?
Hi, Senator. How are you?
Hi, I'm good. Good afternoon.
Good afternoon. Let me just get them to raise the volume in studio a little bit.
Sure.
Right, Senator, let me hear you.
Right. Hearing me?
Yes, I'm hearing
Yes.
you now. Good.
Okay, great.
Good. So, Ravi Balgobin Maraj versus the state local government, big judgment in the Privy Council. I know that you were intimately involved in preparing the case. I assume drafting the case, submissions, that kind of thing. A lot of discussion. Well, first of all, the Attorney General has threatened contempt against anybody who discusses the judgment. So I'm risking contempt, but so be it. So be it. Tell us from the start. What were the main arguments in this case? Why did this matter? Why was this matter filed in court? What was the concern of the litigant, your client? And I assume you as a lawyer interested in the rule of law as well. What was the concern that led to the filing of this claim, and what were the grounds of the case being filed?
All right. So I think you only threaten with contempt if you say that the government lose. So we're both in contempt because I'm saying Frank today they lost.
Right.
Right. The grounds of the challenge were twofold. The first thing was, as you know, there's a general principle in law that you cannot have retroactive or what we say retrospective legislation because it affects either rights that were vested in the past, it may affect a decision that was made in the past, etc. In this case, what we were saying is that when people voted in 2019, I went to the poll station, I dipped my finger, I said 3 years for this person. You cannot come in 2022 and tell me that you've now changed the 3 years to the 4 years.
Yeah.
So I'm trying to break it down as simple as possible
Yep.
for the ordinary person to be able to understand, and I'm not getting into the legal language,
Yes,
right?
thanks for that. Yes.
The other thing is that on a simple reading and interpretation of the amended provision, when it was prospective in nature, meaning that the understanding was that it was meant to apply to the councillors and aldermen who would be elected in the future.
Yeah.
And we found support for that argument, and we grounded that argument particularly in the fact that this miscellaneous provisions local government bill made amendments to a series of acts. And the amendments made to the Municipal Corporations Act changed the whole structure of local government. So the councillors and aldermen elected in 2019, if this bill were to be fully implemented in the coming year, the remaining year that they were supposedly getting by way of the proclamation of that one section, their entire role and function would have changed. Some of them may not have had the qualifications to fulfill those roles under this new regime, because of course it's now, there's a whole new system with different committees and so on sitting in local government.
This is the new package of reform that the government has brought into law for local governments, correct?
Well, it's passed.
Yes.
And but they only proclaimed specific sections.
And that was the issue.
They cherry picked this one section that dealt with the term of office, proclaimed that part, and then said, well, the law now reads that the term of office shall be 4 years, and that means the people in 2019 should be serving for 4 years.
Right.
And we said that makes absolutely no sense because it is prospective in nature, and in any event, the law doesn't allow you to be retrospective, to look at things retrospectively.
Right.
Another thing that we argued, which we also argued, and we've not yet get judgment in that claim, but we had also filed a claim where there was an unreasonable delay in calling an election in the electoral district of Davis South, where, as you know, our councillor had passed away.
Yes.
They had 2 elections in Tobago, and they still would not call the election in Davis South.
Right.
And we were arguing that even though local government is not enshrined in our constitution, there's a specific right that deals with freedom of political expression. Now, that is different from the rights as they are set out in all other constitutions. It was a specific right apart from, you have freedom of expression
Yes.
in almost all Commonwealth constitutions. But back in the day, in the Marlborough House meetings and so on, from our research, that was a specific right that was asked for by the opposition, Rudranath Kapil and others, because they lived in fear of the suppression of political expression.
Yes.
And what we have been arguing is that the right to vote, whether it is in a local or a general election, is the ultimate form of political expression. How else do you have political expression?
Correct.
Except by casting your ballot.
Yes.
Now, because local government is not enshrined in the Constitution, which, by the way, is something that the UNC has been saying we would like to see happen, we did not succeed that it was a constitutional breach. But there was a violation of the rule of law because the government decided to place an interpretation on this proclaimed section and say that they will put off an election. And there's some excellent, what I would say, quotable quotes from the Privy Council about how important it is for persons to be able to not just vote in, but vote out people from office.
If I remember correctly, the Privy Council said it shouldn't have to be said, but let's say it anyway, essentially.
Correct.
Right? Just to remind you. Yeah.
Just to remind clearly the government, because they felt that giving councillors and aldermen one more year to serve was their call to make. Yeah. And the Privy Council was very clear that not the parliament, but more so not even the executive arm, which is the ruling party, should impose representation on the people. Yeah. People's representatives should be elected by nobody but the people.
Yes, correct. And I think another principle that I was very fond of in the judgment, because I think we also sort of raised an argument similar to it in the sedition matter, is that the Privy Council essentially said, look, if you're going to legislate away rights, the language in the legislation ought to be very clear.
Exactly.
And I think that they would have said that in relation to the right to vote as well, correct?
Yes, and it's disputed as to whether or not it's, because I think that was the point at which two law lords sort of deviated, that they didn't see this as being so unclear. But the majority, which is what matters, instead, that, look, the language really wasn't clear. And they said if you're dealing with something as fundamental as voting rights, you have to be explicitly clear. What is interesting, and we raised this at the High Court and the Court of Appeal and again before the Privy Council, is that the model for deferring an election and extending the life of a council existed under the Manning administration, where they were again touting local government reform and saying they're putting off the election because the reform was coming, and I don't think they ever really made any headway with it. But they brought a bill to Parliament, and you would see, if you look at the Municipal Corporations Act, that time-specific clauses towards the end there, the election due on X date is now postponed to so-and-so date. I'll tell you the difference between that and what this government tried to do. That explicit provision made it clear when the government brought the bill that to the people's representatives and the independent bench and everybody else and to the country, that what we are doing is extending the life of the council.
Parliamentary scrutiny.
What they did here was a complete backdoor, roundabout, sneaky sleight of hand way of achieving that and avoiding the scrutiny of Parliament, which is what you would have had when you brought a bill like what was brought under Mr. Manning's administration.
Yeah, and that to me defeats the entire democratic process, because the point of Parliament is to have your elected representatives. Again, we're talking about your elected representatives, but it's to have your elected representatives scrutinize on your behalf any legislation that is to be made part of law in Parliament.
Ask questions, debate it, raise the issue,
try to amend it,
make sure,
and perhaps,
propose amendments.
And perhaps if they had come and said, this is what we also wanted to do with it, maybe someone would have made a suggestion, well, look, the language is not clear, you need to fix it, right?
And, and that's, again, we raised that argument as well, that no way, we went through annexed the entire Hansard of the debates to our claim to show that nowhere did the government indicate that once this law came into force, that it would take immediate effect and the councils would be extended.
Yeah.
In fact, one of our senators had raised the question of, well, why? What is the need to extend the life of the council? And they never answered.
Yeah.
And that is a habit of this government, that the point of a debate, even if we are not opposing something, we will raise questions,
Yeah.
and they just don't answer.
Yeah.
It's disrespect for the parliament, but it's also disrespect to the population, because we don't raise questions because just for our own knowledge. It's for the population to become aware.
Well, ultimately, you have politics, I suppose, and then you have the work of the people taking place of parliament. And as professional parliamentarians, you all will raise issues and try to assist them at least in drafting good legislation. And if it doesn't happen, well, it's only the government to blame, I suppose.
And that is becoming their track record. I've been involved in 3 matters that I could recall off the top of my head that would have involved sloppy drafting, not analyzing provisions, even in subsidiary legislation, enough to ensure that it doesn't violate the Constitution. And all of these things really show that the government just not doing enough consultation, perhaps not listening to the professionals enough, probably not, well, I don't know.
It reminds me of the, I believe it's another case you may have been involved in, the Police Service Commission subsidiary legislation where they tried to...
Yes, that matter. They tried to change the order that would determine how the process to select the commissioner of police. That thing, I mean, you know, they inserted the Minister of National Security into the process to trigger it, which was held to be illegal and was struck out. That was one. The other one is where they amended the order to be able to appoint an acting commissioner.
Yes.
Which is also held to be illegal and in violation of the constitutional provisions.
So they seem to have.
And now they've come again with this one here. And you know, what I find amusing is that the argument that they're trying to run is that, look, there was no deliberate attempt by the government to put off the election, but there was a misinterpretation. That's like saying, I'm not being malicious, you know, I'm just stupid.
Yeah, well, that's like saying I can't read my own handwriting. And I mean, while in terms of penmanship, I could understand that, but you can't draft something and not know what you're drafting. And
well, they know what they're drafting, but they were saying that by the interpretation they placed on it, they are saying that this is an honest mistake, but that this is how they interpreted it. And they garnering support for themselves by saying, but you know, it's not us alone. It has 2 people in the Privy Council and 3 in the Court of Appeal here who agree with us. So it's not we alone that's stupid. That's what they're saying, you know. And I mean, that's ridiculous because it doesn't explain why you felt the need to cherry pick this one particular clause and proclaim it when you haven't proclaimed the rest of it. When they proclaimed this, there was a press conference held, and of course it was part of our evidence that studied that in detail.
Yeah.
And the minister set out a whole timeline of all the other things that were going to happen and all the other things that were going to be proclaimed. How many other things, has he actually done?
Yeah.
None. So your intent, let's go into speak like in criminal law terms now.
Yeah.
Your intent could be inferred. Your intent, as what was the intent of cherry picking this one clause, could be inferred from the fact that you haven't really done anything else that you said you were going to do. Your intent here was to avoid facing the electorate. Full stop. And that's what it is. And that's my opinion. And no threat of contempt could stop me from saying it.
Well, correct. And I'm not afraid of contempt either because I laughed when I heard it. But
yeah, of course. I would. Well, at first I laughed and then I realized how dangerous it is, and as a society, how concerned we have to be about our rights, because you have an attorney general, the second highest officer in the cabinet of this country, essentially trying to encroach upon freedom of the press. That we are on a very, very slippery slope.
And freedom of expression.
Dangerous, to say the least.
And it's always been a principle of law that you know, judgments and judges could suffer the scrutiny of ordinary men. I think that's a famous judgment of Ambad versus the Attorney General.
And the practice amongst lawyers, of course, as well, is that we will scrutinize and criticize judgments, but not necessarily the judge.
That's it.
Certain people in the cabinet didn't get the memo because they will come out and say that judges have friends who are criminals, rather than actually speak to the merits of the judgment.
Correct.
But that is apparently not contemptuous. It is contemptuous to say that the government get the tail properly well cut in the Privy Council.
Well, that's the other part now, and I'm almost embarrassed to ask you about it. But I suppose just for completeness, let's talk about it. This press conference by the Attorney General was an interesting one. Dr. Munilal, in his usual political humor, put it nicely this morning about own goals and away goals and things. But what do you make of this comment or what do you make of the general comments of the Attorney General, essentially counting judges and trying to go ahead.
Look, it was desperate.
Yes.
It was a really pathetic attempt to save face. I felt a bit confused for him and sad because I don't know who was managing this litigation from Trinidad.
Yeah.
But as is the practice, there's an advance copy of Privy Council judgments that's sent out.
Copy,
and so those of us in the know, in the inner circle then, the attorneys involved in the matter, would have known what the judgment was going to be and what was going to be handed down on Thursday morning.
Yeah.
So that bewildered sort of look on his face, not sure, and then grasping at straws the way that he did, was a bit surprising. I will say this, and I still get a lot of flack from my senatorial colleagues for it. When Mr. Almo was appointed Attorney General, I said, well, finally we'll have a senior counsel. I always had a lot of respect for Mr. Almo being a practitioner in the public law arena and so on, in matters that we would have been involved in against him and so on. So I am always very, very disappointed when I hear these things. Something that I was told, and I'm sure, Kyle, you would be told the same thing, is that you do not hang up your robes when you enter the political arena because you are here as a professional and you should not abandon the basic fundamental principles of your profession and essentially make a fool of yourself. So when I speak, I ground what I say in my knowledge and experience of the law. Yes, you want to pelt some lash and all of that, and you're in the political arena, you're down in the Kile, you have to get into all of that type of thing. But you don't step outside of the basic fundamental legal principles and your legal training and so on. You hold fast to that. That is your those are your moorings, right?
Yep.
And I feel very disturbed that someone of the caliber of Mr. Almo as a senior counsel would make those types of remarks in an attempt to perhaps convince the few supporters who might buy into that, when I think the rest of the country now considers him to be a bit of a laughing stock because of those ridiculous comments.
Well, I agree with you. As a lawyer, you have a wider duty to society and to the public. And regardless of what...
And your profession.
And your profession. And regardless of whatever other hat you may wear, you ought not to mislead the public on law, on the effect of law, or at least on the effect of a judgment, and something so simple as to what is a majority and minority judgment.
And when you are a long-standing member of the inner bar, and now you are the titular head of the bar, that duty is so much more important. And if I, as a junior member of the bar, consider that duty to be sacred, like yourself, I cannot see how Mr. Almo could stray so far from it.
Yeah. Let's get into the more tricky part of it. We've had this judgment, and of course there's been a lot of discussion. I saw that you were on today on the newspapers with Martin Daly, Senior Counsel, expressing some opinions as to what is now going to be the effect of the judgment. So you've had this judgment, and it's essentially rendered the extension of the councillors to be not in accordance with the law.
Correct.
What then? There are two phases here. There's the phase between December 2nd, I believe it was, up until the time of the judgment. Thursday. Right. And then judgment going forward. What are your opinions? Let's take the first one. What about acts, contracts, salaries, all things done by local government prior?
When we first filed this claim, we also asked for an injunction, and this was before the end of the term, just before, because they came very late in November with this proclamation. By the time we got into the court, it was November already, like maybe the second week of November and so on. We asked them to injunct the government and to prevent people from acting illegally in office beyond the 2nd of December. Right. That was resisted by the government, and we did not succeed at the first instance court. And then, of course, the 2nd of December came. We did not get a hearing in the Privy Council, in the Court of Appeal until the 20th of December. And all that time, you had 14 corporations with 100 and something councillors and aldermen illegally occupying office, being paid by the public from the public purse, and performing duties that they were not authorized to perform.
Of course, by no fault of their own.
Sorry?
I say, of course, by no fault of their own.
By no fault of their own. They were given a directive from the ministry, which, has authority over them, and they were there, and the court refused the injunction.
Correct, yeah.
So that is what has been happening, and yes, I believe that unless the government takes some swift action to correct itself and its error, the corporations could see an avalanche of litigation. Because imagine the council could sit and decide to give a contract or to allocate money for some purchase or something, and they had no authority to do so. Yeah. Now, as was argued before the High Court when we went for the injunction, and as you would know as well, there's this thing called the doctrine of administrative necessity. Yeah. So because everybody was operating under this misapprehension, and the actual office holders, as you said, through no fault of their own, would have been doing what they thought they were authorized to do. Yeah. You can preserve those decisions. Yeah. The Parliament can also pass what you call a validation piece of legislation to validate all the acts done. My view is that to allow them to continue beyond Thursday to do these things and to occupy office and to perform functions and to be paid is a total abuse. It is wrong. It is illegal. And, for the government to simply sit back, and God knows where they are sitting, because apart from Amor's disastrous press conference, I haven't seen or heard of from anybody else. I think they're all in hiding. And, the country's kind of like local government is on autopilot, just floating rudderlessly and, bouncing around here and there, and nobody knows what to do. And they are just depending on the fact that they will bring a validation act at some point in time to the Parliament, pass it with their majority, and of course not expecting any opposition from, a majority in the Senate or otherwise, and, try to validate these things. But you can't run a country that way. No. You cannot simply allow people who are unelected to continue to hold office unelected, and you are not doing anything to correct yourself.
But that doesn't seem to me in accordance with the rule of law, because if the law is now that you are no longer authorized, I could understand previously, but since if the law is now that you're no longer authorized to do the things that your office is supposed to allow you to do, then
correct.
Yeah, then then a government can't willfully
say go ahead and break the law.
Go ahead and break the law. Don't worry, we'll fix it.
And we go bring something down the road and fix it up.
That is really sad.
It is atrocious. Yeah. It is disrespectful to the population. It is a complete breakdown of law and order and our democracy. Yeah. There's certainly nothing. There's no respect for the rule of law by our government that would know that they lost a matter in the Privy Council, that would know the consequences of that means that you've had people illegally occupying office and acting in office and performing functions for 5 going on 6 months. Yeah. And that you don't have an election date come Thursday. That press conference by Amor was supposed to say nothing more than this is the date for the election. Yeah. And local government, all people elected, debate office today. And that's how it should have been. And, again, they just feel that they can do what they want and nobody will stop them. And that's why they'll say, you all go ahead, do what you have to do, run your corporations, and well, we get an advice, almost, paying for advice. People will advise him, and he will advise Rowley, and all that advice. About a couple $1 million will be spent again.
Yeah.
And
well, I was just
they will do what I could have told them to do a long time ago.
Well, I was just about to tell you, you just gave them advice that I'm sure they're going to pay a lot of money for. Right? They're going to pay a lot of money for. And it may very well be wrong. And I think I heard Dr. Munilal say it this morning as well. The AG could just pick up his phone, swallow his pride, call either yourself or Mr. Ram Logan and get some advice as to what to do. Right?
But, before we commenced this action, we told them, listen, you all are wrong. This is a wrong interpretation. This cannot happen, etc. I would love to see somebody file a freedom of information request to find out how much they've spent on legal fees, High Court, Court of Appeal, and Privy Council to fight down this matter, just to lose, and to have our entire country in a total legal crisis involving people holding office illegally and performing functions and so on, that they're not authorized to do. And now they'll have to, I know Amos says he win, but we're waiting on the cost order from the Privy Council, so I would like to see how much winning Amos will be awarded in cost.
Yeah, that's unfortunate. Before you go, one of the other issues that has arisen recently is this, and I know you made a comment about it, the trial by jury, trial by what seems to be that we're moving
judge
towards
alone.
Trial by judge alone. Yeah, what are your comments on that, and what was that latest bill about? Because I really didn't follow it. I myself had a matter I was dealing with, but is that new bill that came through? I think it came in the Senate first.
It did.
Is it moving straight to trial by judge alone, or is it that it's some movement towards it?
Right. So in 2017, they introduced the option to elect trial by judge alone.
Right.
And they have now brought the most significant provision is that what they are saying now is that rather than you'll be tried by a judge and a jury unless you elect to be tried by a judge alone, they are flipping the position to you'll be tried by a judge alone unless you request a trial by a judge and a jury, and the judge believes it to be in the interest of justice. And then there are some things that the judge must consider that you have advice and whatever. But in the interest of justice, as you know, is very broad and could be interpreted in a number of ways. So the big pushback from the opposition and even the independent bench, because of course there are some criminal practitioners on the independent bench, and they felt very strongly that that is basically taking away that provision to be tried by a jury of your peers and imposing this trial by judge alone. And, we also had a lot of concerns about whether or not, a judge who lives a very cloistered and secluded life would understand and be able to relate to the experiences of ordinary people who find themselves for the court, etc., etc. Some other provisions that I found to be of concern were the reduction in numbers if you were to have a jury trial. Again, you are narrowing the pool of experience that a jury will bring to a trial, and I didn't agree with that either. So the bill has now, given the very strong views coming out from the Senate, coming out from the Law Association, the Criminal Bar Association, etc., it's been sent to a special select committee, which will sit and meet with stakeholders and get their inputs and feedback and so on. At the end of the day, the government is saying that they are much more efficient and faster, and they will help clear the backlog of criminal cases before the court. Right now, as you know, it's a very huge backlog of cases. I don't believe that we should sacrifice justice on the altar of quality expediency and a safe trial for the sake of expediency. Whilst I agree we need to clear the backlog, I'm not sure that this is the route we want to take. I'm also not sure how valuable removing the jury will be in terms of expediting a trial, and that's certainly the area that I will want to interrogate as part of that committee, because to me, at the end of the day, regardless of whether a jury is there or not, you have to call all of your witnesses, you have to allow cross-examination, and I don't know that the jury is contributing that much to the length and delay in a trial. So we will see how it goes from there.
Okay, all right. So thanks a lot, Senator, for joining us on a Sunday. I know that you're very busy both in politics and in the law, and hope to have you on for another topic. Hope to have you on for another PC win.
I hope so too.
All right,
thank you again for the opportunity, and you have a good evening.
Same to you. All right, there you had it. Forensic breakdown of the judgment, the legal issues, and the issues arising out of the judgment. And some laughs about the Attorney General's claim of victory, which is really laughable. I wouldn't use strong language like pathetic, but I would say laughable. So Josh, let's take a quick break and we come back.